Welcome to the new edition of Latest Law. In the next few minutes, we're going to summarise some of the recent developments in the Law of Consultation. It's actually been a very active summer, and there have been several significant judgments which are going to make a considerable difference to those of you who have to organise public consultations. When Rhion Jones was briefing candidates for the Advanced Practitioner Certificate of the Institute recently, he identified no fewer than 12 judgments which are going to be really important. And these are going to cover topics such as when a public body can avoid undertaking a consultation, how a local authority should consult on its budget proposals, what information has to be included in a consultation paper, which is of course Gunning 2, and giving consultation output conscientious consideration, which is Gunning 4. Let's start with an NHS case that's received a lot of publicity. The Clinical Commissioning Group in Corby wanted to make changes to the Lakeside Urgent Care Centre, a walk-in facility that is very popular with patients and the public. For much of 2017, health managers undertook some public engagement and had promised consultation in the new year, then changed its mind, and campaigners went to the High Court arguing that the promise amounted to a legitimate expectation. Prominent among them is Lyn Buckingham.
Corby's not an affluent town. It has a lot of indices of multiple deprivation. The objection is that they needed to involve us to help shape those services, and they didn't do that. But what the CCG kept saying was it was the people of Corby that were using the centre inappropriately. They promised us that there would be a consultation. They were almost setting this engagement up around primary care and access to GPs rather than the needs of the people in terms of accessing urgent care. So they were basing it on that premise rather than we need to change the service of the urgent care. How can we do this?
The judge found in their favour on several grounds. The NHS had broken its promise to consult, and whilst it had possibly consulted on the statutory requirement to involve patients in the development of proposals, it had not involved them in their consideration. The claimants also won on the issue of Section 149 of the 2010 Equality Act. Raising the money for this judicial review had been a challenge. So how did Lyn Buckingham react?
Absolutely brilliant, and you know, we had the faith in the system that would do that. You know, that would look beyond what was being said by the CCG. They were using not the right data. They were giving headline data bits rather than what was happening behind that data. And I think that is, when you're sat in an office, sometimes those data bits, those sort of headlines become the be-all and end-all, and they're not. They are an indication that something needs looking into rather than, you know, oh well, 88% of our people could have used their own doctor.
We've had other cases involving the NHS. As so often happens, claimants will argue that they don't know enough about the proposals and their likely impact to give them the all-important intelligent consideration. One case concerned the centralisation of emergency care in Dorset and whether to do so in Bournemouth Hospital or Poole. It had implications for social care in the area. So had consultees been properly informed and convinced that the required workforce would be in place? The judge said yes, and that the consultation had been lawful. Note, however, that this case may go to appeal. The other high-profile case was the Horton Hospital in Banbury, where the transfer of consultant-led maternity to the Radcliffe Infirmary in Oxford proved very controversial, because everyone knew that a subsequent consultation was being planned that might well involve further rationalisation of the Hortons hospital services. Claimants argued, as in Dorset, that there wasn't enough information to make the consultation lawful. Another Gunning 2 case. But also, as in the Dorset case, the NHS won, though note that the independent reconfiguration panel became involved and severely criticised the CCG's plans. As with Dorset, there could be another twist in this case, as this may now go to appeal too. This is not the only case where the phasing of decisions caused a problem, so I asked Rhion Jones to explain the legal significance.
Timescales is becoming quite a problem. A lot of people will remember the recent situation in the London Borough of Haringey, where there was a big political row. In the end, the Labour leader lost her job because of a major multi-billion-pound redevelopment project. When objectors challenged it in court, they lost their case because they brought the judicial review too late. The decision had been taken several years ago. Now, their counter-argument was, several years ago, when they took the decision to go with Lend-Lease, that's the developer, they didn't know the details which they found objectionable, what the accountability was going to be, what exactly they were going to build, how many homes were affordable. Only now did they say, do we know enough to know we don't like it? They still lost. It takes you back to the Nash and Barnett case, which is all about council budgets and the outsourcing of Barnett's local government services. And that one was also lost on the grounds that the decision itself had been taken a while ago. Phasing is becoming quite a difficult problem. So the Peters case in Haringey, which came out earlier this year, tells us quite a lot about the unwillingness of the judges to allow a case to be heard if the decision in principle was taken some years earlier.
This year, we've continued to see legal challenges on various austerity-related expenditure cuts. As most people know, Northamptonshire Council ran out of money. But when the crisis happened, they were in the middle of acting upon a consultation on closing libraries. It decided to go for a more drastic option and was taken to court for failures in the decision-making process. The case confirmed that no amount of financial difficulties can excuse a council from observing the Gunning principles. Probably the most important local authority case over the summer concerned Bristol City Council. So we've asked Nick Duffin, the Institute's programme director, who knows Bristol really well, to explain the background.
I feel kind of sorry for Bristol Council, really. It's an interesting case because, and we've always regarded the Bristol as being a council that pretty much knew their stuff. They don't usually get challenged on anything. It's not a regular sort of occurrence for them. Traditionally, the shape of the budget is basically where you are looking at how you're going to allocate the budget. Councils all across the UK have been doing this for a long time, setting out the shape of the budget and then expecting the directorates later to go out and consult on the substance, which is effectively how we're going to implement what we've been budgeted with. The issue here is that in the budget, what Bristol had done was decide how much they were going to allocate for special needs purposes in education, decided what the reductions were going to be, and what the judge thought was that, okay, that's fine, providing you're not in a position where that is definitive. But of course, in setting a budget, that was the final stage. And so the judge was basically coming from the angle that actually, really, you needed to be better informed in order to allocate the budget in that way. And the gist of this is that, courts have always been concerned about impacts. To what extent did you understand the impacts on those who this was going to affect? You really need to have a full understanding of the impacts here before you made that decision in the budget. So to what extent do we need to do more detailed work before a budget consultation? And when can we leave that after the budget consultation?
Now for a really significant case. Kohler versus the Mayor of Offices London for Policing and Crime, known as MOPAC. Last year, when the consultation paper was published, there was a flurry of attention when the Institute labelled it as possibly the worst consultation of 2017. Amongst other things, it was proposing the closure of 37 police counters, and predictably it went to court. Not for being a poor consultation. The challenge, when it came, was very specific. Professor Kohler had been beaten to within an inch of his life and had been saved by the prompt action of police arriving from the police station at Wimbledon. As a consultee, he made a response to the consultation, but Mopac could not show that it had been given conscientious consideration, which is gunning for. The judgment raises serious questions about the requirement for those who undertake data analysis to highlight potentially significant responses. It is full of implications for practitioners, and the Institute has published a comprehensive briefing note on the case. As we come to the end of this episode of Latest Law, we're actually going to discuss a couple of cases which involve the law. So we're going to talk about the Ministry of Justice, aren't we, Rhion? And these are two significant ones.
The first involved the network of law centres. Now, you've seen law centres all over the country. They've had a really tough time and their numbers have been decreasing. And this case revolved around a relatively small legal aid scheme. It was to do with people being dispossessed from their homes. And the Ministry of Justice had gone to consultation on a reduction in the number of contracts they would give to different law centres. When the law centres responded to the consultation by saying, well, hang on, what's the evidence that a reduced number of contracts is better? Because the Ministry of Justice had said it'll make the service more sustainable if we reduce them. In fact, there was no evidence, so the whole consultation was based upon an inadequately researched proposition. Now, that was ruled by the judge to be irrational, and it was irrational because the consultation couldn't have been meaningful because the correct information wasn't made available. That's really important.
This is a complicated case, Rhion, but what is the significance?
Well, I think it's the first real case we've had where the courts enforce the principle of evidence-based policy making. And that's something that governments are going to have to take quite seriously.
So that was one legal aid case. What's the other one?
Defence solicitors are paid under the legal aid scheme on a sliding scale that takes into account how many pages of evidence they have to wade through. So this was about a change in that sliding scale to accommodate the fact that increasingly solicitors have got to wade through a lot of electronic evidence. Big row, some of the money made available to defence solicitors was going to go down. A new scheme, how had it been calculated? In the end, the Ministry of Justice was obliged to admit that its calculations was based upon a totally inadequate methodology.
Wasn't that information available in the consultation paper?
You'd expect so. In fact, the Ministry tried to argue that the sophisticated audience of solicitors, that's what they called them, would have been able to work it out for themselves or ask a question if they couldn't find the information they wanted. Now, I have to tell you, the judges were withering in their criticism of the Ministry of Justice. In fact, have you ever in a judgment seen words like this? It is difficult to express in language of appropriate moderation why we consider these arguments without merit. In judge speech, that is about as withering as it gets.
When we're teaching the law of consultation and talking about judicial reviews, one of the grounds for judicial review is that of irrationality. And we've always sort of been saying, oh, but we never get irrational cases. But in this one, both of these were declared irrational. Is that not right?
Precisely.
So hasn't this actually given us a new set of principles?
The judges enunciated 4 principles, 4 considerations that will help consultors recognise when they've got to come clean on their methodologies. In the way that the Ministry of Justice didn't come clean, you need to come clean if any of these 4 considerations apply. Now, we've incorporated that into the Law of Consultation training course, but they are really important. The Leggett Carr principles. They will last, maybe not as long as gunning, but they will last quite a long time.
So, Rhion, we've covered a few of the cases, but there are a few others, aren't there?
Well, this summer was extraordinary in the range of cases that came before the courts. There has been a case on the homeopathy services provided by the NHS. There's been another case in the London Borough of Ealing about the consultation a local authority is having to do in order to control demonstrations by people who might cause a breach of the peace. That was demonstrations by the pro-life movement against an abortion clinic in Ealing. That's a very important case. We've also had the appeal on the Help Refugees case, which Rosa Curling spoke about in the latest law. The Help Refugees charity won their case, but not on the grounds of consultation. So we've had a whole range of cases, and the map will show you how extensive they've covered the country.
And finally, Rhion, the Institute must have been very pleased with Judge Silber's comments on the Dorset case.
Well, it's not the first time that this has happened, but yes, his comments were very welcome. I'm sure Nick and the team in the Institute would have found that very, very useful the next time they're talking to clients who may fear a judicial review down the road. Yes, very pleased with that.
So that concludes our autumn roundup of the cases that we've been through in this summer. We're discussing them in the latest Law of Consultation, and we can also offer it in-house. So we wish you the very best with your consultations as you move forward, and look forward to seeing you on the next edition of Latest Law.